binding himself not to do so, at least during the period of investigation and before the charge?
Thank you very much, my lord. As I have said, the applicant has undertaken in his own affidavit, which is supporting the application.
Yes.
He equally undertakes to keep peace,
Yes.
and comply to the letter of the conditions that my lordship shall give.
Thank you, Mr. Sige.
Thank you.
Mr. Karuni?
I'm much obliged, my lord. My lord, we oppose this application by the applicant. My lord, on the following grounds. Number one, my lord, the applicant should have brought an appeal instead of a revision in this matter. My lord, under section 362 of the Criminal Procedure Code, this court has the powers to call for and examine the record of any criminal proceedings for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding. It is our submission, my lord, that Honorable Carlo, Chief Magistrate, in his ruling, was right in denying the applicant bail in view of the compelling reasons which we demonstrated before him. That there was immense public interest in this matter. And in the interest of national security and public safety, the applicant should be detained to enable police to conclude their investigation. My lord, we complied with the provisions of the Constitution, Article 49(1)(g) and (h), because we informed the applicant the reason for his continued detention. And we demonstrated compelling reasons as provided for in the law.
And what is the reason for continued detention?
My lord, the main reason for the continued detention is the immense influence the applicant wields on the ground as Member of Parliament for Kapsaret that would make the police be unable to record statements from witnesses who were at the scene. problem. My Lord, we are still conducting investigations even today, my Lord. And we are not yet ready to present any charge until we conclude investigation. My Lord, there is submission by counsel that we should have preferred a holding charge. It's not tenable. Because the same would not be accurate in its particulars. As the investigations are still ongoing. And will offend the very foundational principle of certainty of a charge. As provided for under section 134 of the Criminal Procedure Code.
Let's proceed, Mr. Karuri. It seems Mr. Karuri has been frozen out. Mr. Karuri, can you hear us?
Network had a problem, but I'm back.
Oh, you're back, okay.
I'm back.
So very clearly the internet did not like your last point.
Interfere.
Please proceed.
Much obliged, my Lord. My Lord, in the bail and bond policy, paragraph 3, 1E.
3(1)(e).
Yes, my Lord.
Okay.
We submit that the court correctly applied the principles in this policy that bail determination must balance the rights of the applicant and the interests of justice. My Lord, we demonstrated that the applicant would undermine the integrity of the criminal justice system by interfering with witnesses, and it was therefore necessary to deny him bond at this moment. My Lord, the interests of justice demand the protection of the investigation process against probable hindrance by would-be accused persons.
The interests of justice demand
the protection of the investigation process against probable hindrance by would-be accused person. My Lord, my final submission is that if my Lord will be persuaded to grant bail, we would pray that as part of the conditions of the bail, as deposed to by the applicant in paragraph 35 in his affidavit, that he is willing to comply with any orders issued by the court, would be that the court cautions the applicant not to make any insightful utterances.
Welfare enhancing considerations. So the question for you would be, you are roughly aware of what the state is complaining about, the statements you made. Am I right?
Right.
Are you willing not to make those kinds of remarks, whether they are insightful or not? Are you willing to bind yourself not to make them, at least until you are charged?
Yes.
You are?
Yes.
Thank you. Mr. Karuri, a question for you. So, you relied very heavily on the influence of the applicants. And I'm just wondering, quite objectively, is the influence of the applicant any less when he is at Nakuru Central Police Station? Does it drastically go down in threat that now he is being incarcerated here?
My Lord, in my view, it does. The fact that he's at the police station,
Yes,
has greatly cooled down the temperatures on the ground. This is my objective too, my Lord.
For two reasons.
yes.
One, we don't have a criminal case yet. We don't have a criminal case yet because the applicant has not been charged.
Yes.
And even if the applicant had been charged, it is quite low. The latest decision being won by the Supreme Court a week ago, that no appeal lies against an interlocutory decision in a criminal matter. It's quite low. It was submitted by my learned colleague that there was compliance with Article 49, sub-Article 1, paragraph G, to the extent that the applicant was informed of the reason for the detention continuing. Lord, it is indeed true that he was informed. What was the information given to him? That we cannot release you for the reason that as the honorable member for Kapsaret, you are so influential that we cannot investigate this matter unless you are held pending charge. My Lord, there are two birds. One is an eagle with a very big wingspan. It can fly for 100 kilometers without patching. There is also another bird called a quail. Where I come from, we call it isinu. It cannot fly for over 50 meters. You cannot tell the eagle that thou shalt not fly because you have a big wingspan than the quail. Honorable Sudi will continue being the member for Kapsaret until 2022 unless something else happens. So if that be the reason, then that is not a good reason for detention. Lord, lastly, we've been told it is in the public interest and the interest of national security to continue holding the honorable member of the National Assembly for Kapsaret. My Lord, it has been said by courts time without number that when there is a contest between national security and a right in the Bill of Rights, the right must of necessity prevail. That is why here we have mad men outside there making noise. It is their right to be mad. Lord, on the issue of public interest, again, it has been said time without number that public interest is best served by upholding the law. My Lord, we beseech you to uphold the law. This is a matter where the honorable member for Kapsaret should not even be asked to post cash bail. He should be released on his word to keep the peace. We have beseech your Lordship to release the honorable member of Kapsaret so that he may glide for 200 kilometers to his people. Let the quails fly 50 meters, let the eagle fly for 200 kilometers. That is our plea, my Lord.
Thank you, Mr. Harvey. Let me thank all the council for really keeping it very short and for keeping it very civil. I must appreciate that. This is the way we knew the practice of law a long time ago. And Mr. President, you have a big job to return this kind of practice.
Thank you, Lord.
I will, it's now 11:10. Allow me to take about 2 hours to consider the applications and the submissions and the representations before the court. And then in about 2 hours, I'm not promising the ruling will be ready, but at least you will get information from my assistant if it is ready. If it is ready, then a Zoom link will be sent and I will read it just like we've done here. Does that sound okay?
That's fine, my Lord. Almost.
So for now, but for now, let's say I will read the ruling at, actually let's make it more certain. I will, let's put the ruling at 2, unless you hear from my assistant otherwise that it's not ready, then we will tell you when it will be ready. But for now, let's plan to come back at 2.
Thank you.